afternoon. My name is Adriana Damianova. For the record, I am lead environmental specialist and program team leader for Europe and Central Asia on environment, specifically areas concerning pollution management, environmental policies, and lending for environmental improvements. I'm in Washington, D.C., and I have been working for quite some time on Armenia. I'm quite familiar with the issues in Armenia. I worked with Honorable Mr. Acopian for quite some time. I want to say that after the preceding speakers, it would be hard to deliver a speech which is so inspiring and so substantial, but as World Bank, I would like just to express an opinion, and this is how we work with the government. We provide comments, we express our views, but ultimately this is the responsibility of Armenian government, Armenian public to decide on the pieces of legislation, and therefore my presentation is gonna talk about environmental impact assessment good practices, about the mining code, and about the issues which we see that needs to be taken a step further in order to really ensure good environmental management practices in the mining sector. Again, as it was said in this room many times, the environmental impact assessment is an important tool which is to inform the decision-making process. EIA document is the substantial carrier of information which the decision makers and public have to be familiar with. Who is involved in the environmental impact assessment? This is the government agency, the ministries, project proponents, consultants who prepare the environmental impact assessment document, and the public. The new environmental impact assessment law of Armenia, which is still in a draft, in our opinion, translates a lot of good best practices which are internationally recognized. There are issues, of course, that need to be clarified in much depth, but we understand that there are bylaws or ordinances or additional documents which will be prepared. Some of them are in drafts, and we would be happy to provide comments on that as well, just to understand how the process will evolve to fully translate the good international practice. Environmental impact assessment stages. I'm not going to repeat. The previous speakers talked about this. I think it's important to understand the process and the role of various agencies and bodies in the process, particularly when it comes to the implementation in the mining sector, given the fact that the mining code has been approved 2 years ago. And obviously, a lot of responsibilities are vested in the Ministry of Energy and Natural Resources. Public participation, there is a lot of discussion about this. Obviously, public participation is key in the environmental impact assessment process because people living near the site know best how they will be affected. But as the previous speakers mentioned, this is more of a consultative process to hear the opinions and views, put them on record. But when it comes to decisions which are concerning the entire economy, three major points have to be considered: economic sustainability, social sustainability, and environmental sustainability. a good equilibrium between the three will guarantee that a good decision will be made in each and every case. I would like just to put on the table the list of mining sector activities which are under category A for people to be familiar with this, who are not entirely familiar with the law. And a few articles which are very important and which are the linkage with the mining code. For example, Article 15, which defines the two phases of expert examination, preliminary phase and main phase. These are included in the mining code and in the supplemental environment and social guidelines, which have been approved a year ago by the Ministry of Energy and Natural Resources. Again, this is from the law. Article 16 talks about the preliminary examination phase. Previous speakers explained what is the requirement according to the proposed law. Article 16 also provides the information on the basis of which the competent authority is going to make the decisions, yes or no, which is part of the process. I want specifically to highlight one item in Article 16, which says the concept document or the proposed activity shall be subject to impact assessment pursuant to the terms of reference. A few speakers mentioned about the terms of reference. This is a major improvement of the law on environmental impact assessment. We consider it a milestone provision because the terms of reference, if well prepared and site-specific to each proposed project, will lay the basis not only for the decision which have to be made, but also will inform the review process and will allow to have a basis on which all the players have agreed to work and substantiate during the preparation of the environmental impact assessment. Therefore, the gap currently which exists in the law has to be supported by additional document, which is either guidelines or a decision of the Ministry of Environment Protection, or a document really which is binding and also provides sufficient information on what the terms of reference should be in order to avoid extensive disputes back and forward between the key actors in the process. Typically, the terms of reference are comprise project description, institutional framework, listing the agencies responsible for overseeing the environmental process, applicable laws and regulations. This is the general content of the terms of reference, but then it has to be very specific to the site. Impacts and issues to be studied related to the site, mitigation and monitoring system to be designed specific for the site, specific for the processes, specific for the technology. Provisions for public involvement, key stakeholders. This is requires very careful definition of people who are immediately affected, but not only in the immediate vicinity, but also downstream and upstream, which is a little bit a step further. That is in the philosophy of the cumulative impact assessment. Key stakeholders, time frame for completion of BIA, expected products and deliverables, and budget for the EIA. Article 19 talks about the main phase of expert examination. There are certain provisions which need to be looked through the lens of the mining sector and what are the provisions of the mining code. This is the submission process and how the submission process of the EIA at preliminary phase and at a later phase will be done through the one-stop shop, which is a good practice for the mining sector. However, unless it has very clear definition, who does what, some ambiguity will remain. Article 19, item 4, talks about the deadlines, which is, as it is in the proposed law now, 16 days for concept documents, 16 days for category A proposed activities, and up to 40 days for category B. These provisions need to be translated into the implementation guidelines for the mining code and the guidelines which are related to the one-stop shop, how it will operate in terms of implementing environmental provisions. This slide basically is to, as a segue to talk about the provisions for environmental impact assessment which are included in the mining code. But I want to start with saying that the mining code and environmental impact assessment law, the draft which is under discussion in the Parliament, they have very important common features. The Mining Code, Article 1, acknowledges the requirement for mining to protect nature and environment from negative effects, ensure security of works during mining, as well as protection of rights and legitimate interests of state and individuals. Environmental impact law, the draft Article 6, says that environmental impact assessment aims at projecting, preventing, reducing, or excluding any potential harmful effects on the environment and human health caused by the enactment of concept documents and proposed activities. I just wanted to mention this because there is a common ground to make sure that environmental impact assessment process is fully implemented in the mining sector without any compromises. However, there are certain issues that I want to talk about in the following slides. The mining code defines 4 documents related to environmental matters. Environmental impact assessment, which is a different term, but I think this is due to translation probably of the version which we've got. Environmental management and monitoring plan, preliminary impact assessment on the environment and nature, that's how it is translated, and mine closure plans. These are really very good points to start. Mining code refers to permits, 2 types of permits, exploration permit and extraction permit. These are the permits which are issued worldwide. There is no much difference, and this is a good practice. Mining code refers to geological exploration permits in Article 39, Article 14, Article 41, 42, 44, 46. Why I am referring to these articles? Because we see here some discrepancies in the timing for processing, and our recommendation is to the Ministry of Energy and Natural Resources to think about realigning those deadlines and processing time in the implementation guidelines, which is a document that can be revised at any time. The mining code provisions on the preliminary environmental assessment and environment and social impact assessment are pretty close to the definition which is used in the environmental impact assessment law, which is a good starting point. Objectives are also quite well specified. Environmental management and monitoring plan as well. And this is because they borrowed the concepts from the IFC guidelines, which are considered best practice, but everything is how they will be implemented. There are many laws which on paper read so well that you cannot say, oh, this country has a problem. However, if there is no capacity, if there is no oversight, if there is no accountability how the implementation of these documents takes place, then obviously the result would not be so good. Mine closure plans are included, and I must say that what we see in the environmental social guidelines is quite good and is aligned with the IFC guidelines for the purpose. There are issues, and I want just briefly go over this before I finish. Article 36 has to clarify which is the authorized entity when the application process takes place and who delivers the application to the environmental expertise in the Ministry of Environment Protection. The work plan, which is in the law, in the mining code, talks about work plan for geological exploration, which inter alia, which means that among others, includes preliminary assessment of nature and environmental impacts, including the environmental plan. Here the definitions are quite broad and needs to be more precise. Article 39 talks about work plan of geological exploration for the purpose of mining. Here we see in item 4 quite a good reason to make it more harmonious to the environmental impact assessment law definition on the preliminary assessment. Article 40 talks about decision on application on geological exploration right for the purpose of mining. Here a major harmonization is needed in order to include the terms of reference, because as we spoke about the terms of reference, this is a milestone to be sure that all parties agree on how to approach this environmental impact assessment. Article 50 talks about the mining plan, which contains, Article 50 talks about mining plan, which shall contain in item 4 assessment of nature and environmental impacts, including a plan for environmental management and monitoring, reclamation of the affected lands. Needs harmonization of the wording in order to be fully compliant with the environmental impact assessment law. Article 51 talks about taking decision on application for obtaining the mining right. Again, harmonization with the environmental impact assessment law would be useful, either in the implementation guidelines or if the ministry is going to propose changes in the mining code, this is the place to. Either way is good, as long as implementation is happening according to the provisions.